everyone, welcome to the community classroom. This is Dr. Tracey McCarthy. This is our follow-up in the community classroom. This is our community law school series, and we are going to cover the American, as in U.S. legal system overview. We're going to look at the courts today, and we're going to quickly go over this. We're going to try to keep it within our time limit parameter there. And so quickly what we're going to cover is a refresher on the branches of government, the levels of government, the sources of law, the facets of law, and the primary areas of law. And then we're going to go over the state and federal court systems so that you can see how they look and how they link together. And first, let's define law. Law is basically the rules of conduct for a particular group, a social group. And these rules are established and enforced by any authority or legislation or custom of a particular community or sovereignty. And it doesn't matter the size of the sovereignty. This is pretty much the understanding of law across the globe. And so it can vary in terms of the community or the sovereignty, but this is pretty much the understanding of what law is. And some other words or letters that you might see that are related to law so that you can be alerted to you're looking at something legal is lex and jur. So things like jurisprudence and jurisdiction, those things, lex talionis, those things suggest that you are talking about the law. And as a reminder, we have three branches of government. We have the legislative branch, which is made up of the House and the Senate. We have the judicial branch that is made up of the courts and includes our judges and our justices. And we also have the executive branch, and the executive branch is headed up at each level by the chief executive officer. So at the federal level, we have the president. At the state level, we have governors. And at the local level, we have our local municipal mayors. And these branches all have distinct duties, although there is some overlap. So the legislative branch actually creates the laws, and the judicial branch interprets the laws that have been created. And then the executive branch, their job is to enforce the laws. And so in addition to presidents, governors, and mayors, in terms of the executive branch, you have police officers, of course, and there is another entity that most people don't realize is part of the executive branch, and that is the prosecuting attorney. And so the job of the prosecuting attorney is also to enforce the law. And for each branch of government, we have levels of government. And so there is the local government, and that's the city, municipality, township level of government. Then we have the state level of government, and then we have the national government, also known as the federal government. Now, of course, many people will say there's a distinction between national and federal, but for our purposes, we'll just think of them as one entity, national and federal. And to recap the discussion on sources and types of law from the sources video, we have a variety of sources of law. That means the places that we get law from. The first major place is the Constitution, and we have constitutions at the federal and state level. And so there's one federal constitution, and then each state has its own constitution. And then there are statutes that are our codes that are on the federal and state level. And then we have what's known as case law, common law, judge-made law, and this is law that is made by the judiciary. And then we have administrative rulings, and this comes from the executive branch actually. And so when they make rulings, they become enforceable. And then we also have international treaties, and international treaties are very important. International treaties are on par pretty much with the Constitution. So as long as they are not in conflict with the Constitution, they carry the same weight. They carry the same level of power. So they're very powerful things, and that's why they should not be entered into lightly. And many people don't realize that the law has facets to it. And so there's substantive law and there's procedural law. And substantive law is basically, what is the law? What does the law say about what constitutes a crime, for instance, or what constitutes a tort, for instance, what constitutes a valid contract? That would be substantive law. Procedural law is how the law is applied. And so the court process, the legal process, the criminal process. And you can find information on both substantive and procedural law in the statutes. And there are two primary areas of law and practice. It's criminal law and civil law. And within criminal law, you have adult and juvenile. Juvenile is an unusual area of law because it encompasses criminal aspects and civil aspects, and it's generally handled by what's known as the family court. Sometimes you'll have just a straight juvenile court, but it's usually under the umbrella of the family court. And so criminal law situations involve the sovereign or the state or the government against an individual or an entity, and civil law issues involve private matters, and so they are not, it's not involving violations of the criminal code, and so it's usually some sort of personal harm that has taken place or some sort of personal dispute. You will know a criminal law situation because it will say the state or the government versus an individual, and with a civil situation you will generally see private party versus private party, although the government may be a party to a civil issue. And within criminal law, you have adult criminal procedure, and then you'll have juvenile procedure. And so the procedural law for adult criminal activity and juvenile delinquency, those are separate laws. So when you're looking in your statutes, you will look for the procedural laws for those two issues in different places. And so you have both law and procedure, or substance and procedure, for both adult and criminal dynamics. There are a number of areas of civil law which are distinct from criminal law, and when you look at lawsuits, the lawsuits generally revolve around one of these areas, and it's torts, contracts, property, family, domestic relations, juvenile. Remember, juvenile sort of straddles the fence of civil and criminal, and then you have business, wills, trusts, and estates. And sometimes, even though these are civil law areas, there's sometimes some overlap, and so a particular action may constitute both a crime and a civil wrong. And when that happens, you would have two different court processes. So you'd have a process for the criminal issue, and then you'd have a process for the civil issue. And with the criminal issue, the prosecutor would be the one bringing the case. And in the civil issue, there would be a private attorney bringing the case. And there are a couple of esoteric areas of law for consideration, and they are admiralty and intellectual property. And most people don't deal with these two issues generally. However, if someone is involved in some sort of creative endeavor or discovery, or they are involved in some sort of admiralty endeavor, they may be involved in admiralty or intellectual property law. And intellectual property law, just for your awareness, it involves things like patents and trademarks, anything that has been created or something that's been discovered. And of course, there's some debate about whether or not people are actually discovering things sometimes, but that's what intellectual property is about. It's about creation and discovery. Now, this is a look at the federal court systems. You might call them the system, but there are different systems within the system. And this is distinct from the state court system. And so we're just going to quickly look at this. And basically, the important thing to remember is that there are 94 district courts, and there's a district court in every state. And the federal district courts hear federal matters, or issues that are related to diversity of jurisdiction, where you've got parties that are from different states. And this is basically the district courts. Those are the trial level courts, and that's where you have the basic trials. And then after that, if there is an appeal, it would go to one of the circuit courts. And the circuit courts are basically regional courts, and they cover different regions. Now, with the district courts, there's a district court, at least one in every state. And if it's a large state, they may have more than one district court. But with the circuit courts, they cover regions. And so sometimes you will hear about a circuit decision. For instance, the Fifth Circuit covers Mississippi, Texas, Louisiana area. And then New Orleans is sort of the headquarters for that particular circuit. And then you have, so there are 94 of the district courts, and then there's 12 plus 1 of the circuit courts. And so that's 12 plus the Federal Circuit Court of Appeals, that U.S. Court of Appeals for the Federal Circuit. And the federal courts handle basically federal issues. And so they handle issues related to, veterans. They handle issues related to the tax code. So they handle those sorts of issues, international trade and federal claims and things like that. And again, it can also handle matters where you have citizens from two states, and that's called diversity of jurisdiction. And what is known as the court of last resort is the United States Supreme Court. It is the highest law of the land. And it is also an appellate court, but it is the ultimate appellate court. And once the Supreme Court has made a decision, that decision is final and it's binding on all of the courts that are under the U.S. Supreme Court. One thing that's important to note about the federal Supreme Court is that there is no right to be heard by the federal Supreme Court, and so permission has to be granted to be heard by the Supreme Court, and so a writ has to be filed. But it's important to note that very few cases ever make it to the Supreme Court. I think it's less than 1% of requests are actually approved, so you very rarely hear about many cases that are even filed to the Supreme Court, because the Supreme Court does not accept them in terms of review. And another important note, if the Supreme Court refuses to hear a case, then the ruling from the lower court is the decision that's going to stand on that particular legal issue. And finally, let's look at the model for the state court systems. Now, each state court system is going to vary a little bit, but this is the general model for how they look and how they operate. And so within the state court system, it's a little bit more simplified than the federal system. You have those local courts, those municipal courts, and then you have the trial courts of general jurisdiction. And so you might notice them by words like the Court of Common Pleas, or you might see something that's called the Circuit Court in your particular state. And then for most states, there is an intermediate court. Just like the circuit courts at the federal level, you have the appellate courts in the state court system. And then for the state courts, there's also a court of last resort, which is the state Supreme Court. And then if there is an appeal that's required from the state Supreme Court, that would not go into the district courts of the federal system. It would go straight over to the United States Supreme Court. But again, you need to remember that permission still has to be granted by the United States Supreme Court to be heard by the United States Supreme Court. And if it's a civil matter, for instance, and an individual is attempting to sue a government entity, permission has to be granted by that entity because they hold what's known as sovereign immunity. So you need to remember that. Thank you for joining us in the Community Law School classroom. Remember, knowledge is power. Take care and see you soon.